retiring in December. Yes, sir.
Wait for a few days. We'll do them.
Bylaw from this list, bylaw. Serial number 35 and serial number 43. On behalf of Mr. Light will argue this case. I am suffering some eye problem. I can't read properly.
We will not adjourn cases on mentioning. You be here when the case is called.
Okay.
For judgment item 1, the LPS 3465 of 23.
This petition is dismissed.
Item 2, WPS 5491 of 2023.
This petition is dismissed. Dismiss.
For orders we deferred item 6, criminal division 125 of 2023.
Yes, your Lordship, I pray for 2 weeks time for nobody defecting.
Council for the time till how much time?
2 weeks time.
2nd of July is granted to the petitioner to remove the surviving defects preemptively. If the defects are removed within time, goes this case on 4th of July. You have to meet it.
Item 7, criminal division 132 of 2023.
और 4 जुलाई को हमारी कितनी केसेस हैं? इधर कोई फिक्स नहीं हुआ है, सेम ऑर्डर.
Item 8, criminal division 135 of 23.
Same order.
Item 9, criminal division 136 of 23.
Same order.
Yes, your Lordship.
Item 10, criminal division 142 of 23.
There is different one for filing petition.
You file it. I am giving preemptive time, same order. It's a preemptive time, 2 weeks. It will come on 4th. If you remove the defect.
Item 11, criminal division 143 of 23.
Your Lordship, surrender certificate not.
Same order.
Oh,
Item 12, criminal division 145 or 23.
Same order.
Item 13, criminal division 151 of 2023.
Defect है ना? Check कर लीजिए. Same order.
Item 14, criminal division 162 of 2023.
Same order.
Item 15, criminal division 168 of 2023.
Same order.
Item 16, criminal division 171 of 2023.
certificate is one thing.
Same order.
Item 17, criminal division 176 of 2023.
Same order.
Item 18, criminal division 180 of 2023.
Same order.
Item 19, criminal division 181 of 2023.
Same order.
Item 20, criminal division 183 of 2023.
Same order.
Item 21, criminal division 194 of 2023.
Same order.
Item 22, criminal division 197 of 23.
Same order.
Item 23, criminal division 1203 of 23.
Same order.
Item 24, criminal division 212 of 23.
4 weeks time maybe.
By 4 weeks.
Time all the typed copy are not eligible. therefore they have been qualified.
Sorry. दिखाई जाए इनका फाइल.
Or maybe you
Only annexure 2 का आपको टाइप कॉपी देना है. Annexure 2 में कौन सा पेज आप इग्नोर कराना चाहते हैं बताइए. Tell us. Annexure 2. What is annexure 2?
it is the order sheet of the law.
So इसमें आपको 4 हफ्ता चाहिए.
ये
इसको टाइप कराने के लिए आपको 4 हफ्ता चाहिए. ऑर्डर शीट
कराना
2 हफ्ता बहुत है.
maybe
Same order. We will not ignore it. You have not made a prayer for ignoring it.
Item 25, Conversion 2 and 3 of
2 weeks
23.
time frame. It will come on 4th.
Item 25,
this time
We also same prayer lordship surrender certificate.
Same order.
Item 26, Conversion 219 of 23.
Same order.
Item 27, Conversion 225 of 2023.
Same order. It's preemptory order, madam. Ensure compliance.
Item 28, Conversion 227 of 2023.
Same order. Petition.
Item 29, Conversion 228 of 2023.
2 weeks.
Same order.
May I mention, there is one case order with defect where the one defect is to be removed.
You never appeared. Which
Yes,
defect is
my
that?
relative.
Which item?
It's item number 20, Your Worship.
20.
20.
20 का फाइल दीजिए. Which is that defect you want?
It's enclosure number 125 at page number 34 will be filed by way of supplementary affidavit, Your Worship. This page 34 is the FIA, Your Worship. These are the enclosures which has been mentioned in the written report of the first information report, Your Worship. These enclosures have not been provided by us when we applied for the certificate.
Let us see the certified copy. Let's have a look at the certified
Yes.
copy.
Page 34, Your Worship. Defect number 92.
The certified copy of the FIR is not on
A
record.
certified copy of FME, Your Worship. The last line,
The certified copy of the FIR is not on record.
it is on, not on record, Your Worship, because in revision we just give a photocopy of that. We can give the certified copy, but that is so Anulangan mein, Your Worship, there are the
Where is it?
enclosures.
You said page number 30?
Page 34, Your Worship. Page 34, Your Worship. There is a Anulangan on last me, Your Worship. CA number 125. अनुलंघन में उपयुक्त का कार्यालय गोपनीय शाखा का पत्रांक 948/2 गोपनीय दिनांक 12/12/2019 संलग्न आपूर्ति. नंबर 2 इज आपूर्ति आदेश. नंबर 3 इज सभी प्रखंड विकास पदाधिकारी का जांच प्रतिवेदन.
Criminal revision number 183 of 2023. Counsel for the petitioner has submitted that the enclosure to the FIR,
Yes, Your Worship.
altogether 5 in numbers, were not provided to the petitioner along with the certified copy of the FIR whose photocopy has been filed in the present case. This case arises out of
It's a discharge application. Under section 239 in the
Just a
order.
moment. This case arises out of GR case number 435 of 2020. corresponding to Sindega PS case number 23 of 2020. Counsel for the petitioner is directed to apply for fresh certified copy of the order, and the learned concerned court is directed to provide the certified copy of the order along with its enclosure to the petitioner to ensure removal of defect in the present case.
I have the certified copy
Let
of
the
that.
needful be done by the petitioner by 9th of July.
Just fellowship 1 week more because to get the certified copy. Sometimes we don't get
16th of
the
July.
16th of July. Otherwise, I have the certified copy of FIR. The entire
Please, you file, you,
fresh copy.
yes, yes, like that. Let this order be communicated to the concerned court through fax. Post this case on 18th of July under appropriate heading. In the meantime, it will be open to the petitioner to remove the surviving defects.
For orders item 30, CP 3 of 2002 along with item 31.
These matters are being listed at the instance of office on account of typographical error in order dated 12th of June 2024, wherein the matter has been directed to be posted on 19/7/2024 instead of 19/6/2024. Considering the aforesaid facts, the order dated 12th of June 2024 is hereby modified to the extent that, in paragraph 4, the next date be read as 19/6/2024 instead of 19/7/2024. Post this case on 19/6/24. Have you received instructions to file an affidavit?
No, on the 17th, we have received the supplementary affidavit. They have filed the respondents. We want to file a rejoinder to that.
What supplementary affidavit has been filed?
They was asked to bring on record that the both the petitioners and the company has been merged with sale.
Yes, so if it has been merged with sale, what will happen to this case? Isn't it? Now you will have to sue sale because they are successor in interest. This binding up petition will not survive anymore. Please take instructions. These are all infructuous matters. Please don't.
Yes, yes,
Right. And binding up by itself is not a recovery suit. So whatever be your right, that will be intact. Whatever be it in accordance with law, we are not concerned. Right? Receive instructions. It will come tomorrow. Next.
Item 32, WPC 6566 of 2020.
Madam, you wanted to withdraw. Serial number 12.
Serial number 12.
With
Order
the
modify करना है.
with the liberty to raise all points in the trial.
It is against this charge.
It is against this charge, the trial has proceeded.
Learned counsel for the petitioner, Mr. Pandit Neeraj Rai, submits that on account of change of stage in the case, he wants to withdraw this case with the liberty to raise all the points before the learned court at the stage of trial. Considering the aforesaid prayer, this petition is dismissed as withdrawn. Liberty is reserved with the petitioner to raise all the points which may be available to the petitioner under law at the stage of trial.
I'm sorry.
You need to put
My
your signature.
apologies for the non-appearance.
No problem. You put your signature, please.
Item 32, WPC 6566 of 2022.
Yes, petitioner.
Ladies, I file a IA for
For,
substitution of notice also.
for substituted notice.
Notice.
Okay. In which newspaper?
For the respondent number 6 to 8.
Where they were, what is their last known address? What is their last known address?
Last known address will also be stated on the petition. Ranchi also. PS will be Lalpur.
Why this case has been listed before me? So is it an assignment?
2022.
This WPC? ये हमारे पास है? देख के बताइए ऐसा. Why is this case listed before me? Is it an assignment? On 10/6 this case was taken up. Earlier 227 में फाइल हुआ था, then 226. It has been modified to 226. Check करके बताइए. You just pass over. This is being passed over for a few cases. Come at 11:30. We'll find it out. Why is this case listed before us?
Item 33, Resolution 869 of 2023.
This petitioner. LCR.
Which the outset notes, they just submit one thing. This is 125 matter, and it is coming for final hearing. The depositions are not with me. So I just asked my senior.
On the last date, your junior was appearing.
Yes.
And he was given the records of this case. He wanted to go through the records.
Yes.
And therefore the matter was listed today.
Yes.
Now another person is appearing and saying that.
No. He is my junior. I'm not appearing as if I had sent him. Actually, but the records are here, and I just wanted a photocopy and just take. I tried
you
to.
Can't get a photocopy from
No, I'm taking from my senior. I just asked. I made a to my senior also that if he could give me so that it comes next week.
No.
There's no stay. There's no stay.
Need not be any stay. You see, we have gone through the records. It's just a few pages. Your junior was saying that he wanted to rely upon the WhatsApp chat. Correct? Where is your junior? He should be here. Where is he? This. You can do it in the second half. Go through the records. Pass second half. Yes, it will be taken up. Records, वहाँ रख दीजिए. Let them see the records. Have you seen the records, Mr. Majumdar?
I have all the with me.
You have additional copy? Do you have additional copy?
Certified copy of all the exhibits and everything. Deposition, sir.
ठीक है, second half.
For principal item 24.
Sorry?
Item 34 wrongly listed. For admission, item 35, WPR 3188 of 2014.
Yes, petitioner. Okay, WPL number 3188 of 2024. Nobody appears on behalf of the petitioner. In order to give one more opportunity to the petitioner, close this case day after tomorrow. Mr. Mehta, this is BCCL matter. Are you appearing for the respondent? Amicus appoint कर देते हैं. People are not appearing. We can't help it.
Just check.
We'll appoint an amicus.
This is item number 35. And I'm appearing in 36.
What about 35?
Your Lordship has been appointing.
Adjournment के लिए क्या कर रहे हैं? She is not here. कुछ आँख का प्रॉब्लम बता रहे थे मिस्टर एस के लाइक. मिस्टर मेहता इसमें रिकॉर्ड कॉल फॉर कर देते हैं.
ठीक है.
Because बाद में सुनने के बाद
ठीक है.
रिकॉर्ड करने से क्या फायदा है?
All right,
है ना?
I'll take charge of that.
It's a matter of obtaining appointment through forged documents.
Okay. And dismissal,
And dismissal.
and which is under challenge. So
Let's
what
call
I'll
for
do
that.
is, if no one is appearing for respondent, maybe earlier
I'll provide you a
Justice Sen was
soft copy
appearing.
of the records.
I'll get it. Probably Justice Sen was appearing earlier.
Yes.
So I'll check up if it has not been allotted.
You enter your appearance. Do you enter your appearance by filing wakalatnama in BCCL matters?
Yes, I do.
Please do that.
Or if your Lordship passes an order that I'll appear, so I'll appear.
No, I can't direct.
All right, Lord. I'll.
WPS number 3188 of 2024. फिर से लिखिए. Nobody appears on behalf of the counsel for the Mr. A.K. Mehta, who normally appears on behalf of Bharat Coking Coal Limited, is present before this court. He submits that he shall seek instructions and take appropriate steps in the matter. Earlier, he was never allocated this record. Office is directed to provide a soft copy of the records of this case to Mr. Mehta for needful. Considering the point involved in the present case, office is directed to call for the records from the court concerned. इसका डिटेल दे दीजिएगा कहाँ से आएगा records. Pose this case on (16th of July).
Lordship may appoint some amicus.
You see, it was being mentioned in the morning
Okay.
on account of some
Then
senior
it's all
counsel. Therefore, I am not appointing.
Right.
Item 36, WPL 5833 of 2014.
Yes, petitioner.
Four 69 employees, work was taken from them, my lord, from 72 to 78. My lords, without going into the detailed merit of the case, I only want to draw my lord's kind attention to the award, which is at page 22 of the petition, my lord, page 22. And if my lords will peruse the award, it has got no semblance of an award, my lords, for the reason that it is in a very cryptic manner, no reasons have been supplied, my lords. And in
Yes,
one
Mr.
page,
Mehta, what is to be done with this award?
so it has to be remanded, my lords. So many documents were placed and in a cursory manner, my lords. After all, reasons have to be supplied, my lords.
How many witnesses were examined?
469.
How many witnesses were examined on behalf of the workmen?
2, 3 witnesses. I got the file yesterday only, my lords. The detailed facts. But when I saw the award, my lord, one order just to buttress my
There are
point.
witnesses examined, Mr. Mehta, this award cannot sustain.
Yes, I'm giving that number.
इसका भी देख लिया जाए। रीजन का क्या इम्पोर्टेंस है? एक सिमिलर मैटर में रिमांड हुआ था, इफ सब्जेक्ट टू माय लॉर्ड्स प्लेजर 678 for the same reason.
WPL number 5833 of 2024. The learned counsel for the parties are present. You just give me the number of those.
Yes, the number is 6053
Six
of 2018, WPL. my lord.
53
The
of
Lordship's order.
2018, yes.
Yes, the order dated is 8/4/2023.
Day before yesterday
Yes,
also I
yes,
passed.
your
What
lordship.
is the number you remember?
That case number.
नंबर अपने जूनियर को बोलिएगा, हमारा ऑफिस को पता नहीं
हम दे देंगे।
लगता दे दीजिए।
Yeah.
ठीक
But this is the judgment based on which your lordship has done. And the same judge,
Done.
CGIT number.
The learned counsel for the parties are present. This petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the matter relates to regularization of 469 employees working under respondent BCC, and the impugned order is ex facie perverse inasmuch as the same cannot be said to be an award in the eyes of law at all. The learned counsel has further submitted that the materials placed on record on behalf of the parties and the evidences adduced by the parties have not been discussed in the impugned award. No issues have been framed. It has been in para 1 of the award, the list of workmen has been given. In para 2, it has been mentioned that both the parties had filed their written statement. Para 3 mentions that the workmen claimed that they were working in BCCL under a contractor, but subsequently, without regularizing them, the management terminated their services. And thereafter, it has been mentioned in paragraph 6 that as per the evidence, they have all stated, the workmen, as per the evidence of the workmen, they had stated that they are working under the contract. The learned counsel submits that the materials on record having not been examined as per law, the impugned award calls for interference. Yeah. The learned counsel has relied upon an order passed by this court in WPL number 1352 of 2017, dated 21/9/2020, and has submitted that
6, my lord, from para 6 onwards, operative portion.
and has referred to para 6 onwards of the said order to submit that the award being cryptic, the same cannot be sustained in the eyes of law. Counsel for the respondents, the learned counsel has submitted that the matter be remanded back to the concerned court for fresh consideration on the basis of materials already available on record. The learned counsel appearing on behalf of the respondents has submitted that in case this court is inclined to remand the matter, it may be observed that the materials on record be considered.
Because our case is that they were working through a contract.
And it is their specific case that
They were not working under
workmen were
BCC.
working through a contractor and not directly under BCC.
They might have worked. This is our case.
That's your case
Yes.
specifically.
That's
This is disputing 90% of the cases, my lords.
After hearing the learned counsel for the parties and after going through the impugned award, this court finds that the matter relates to as many as 469 workmen, and the learned tribunal has passed a cryptic order without discussing the materials on record. It is not in dispute that both documentary and oral evidences were led by the parties before the learned court concerned. Tribunal है ना? Before the learned tribunal. In view of the order passed by this court in WPL number 1352 of 2017 dated 21/9/2020 and subsequent order passed by this court in WPL number 6053 of 2018 decided on 8/4/2023 and there is one more order. अभी किए थे किसका था याद नहीं. Just give me the number. And having gone through the impugned award, this court is of the view that the impugned order is cryptic and cannot be sustained in the eyes of law. The matter, accordingly, the matter is remanded back. कब appear होइएगा आप लोग? कब बताइए?
Problem is the tribunal is not there. ये भी दिक्कत है.
Appear तो करेंगे ना?
हाँ appear हो सकते हैं.
नहीं तो क्या
Registry में.
notice वोटिस बहुत दिक्कत है.
हाँ नहीं.
रजिस्ट्री में आप
Registry
appear
में
होइए,
appear हो
उसके बाद जो
जाएगा.
डेट
हाँ,
पड़ेगा
तो-
पड़ेगा.
हाँ.
डेट ऑफ appearance बताइए.
He is saying 4 weeks. After 4 weeks.
The parties are directed to appear before the learned tribunal on 18th of July 24, and upon their appearance, the learned tribunal shall pass fresh award after considering the materials which are already available on record and take expeditious steps for expeditious disposal of this. No fresh evidence.
Yes, sir.
No fresh evidence. जो है उसी में award.
हाँ, उसको भी discuss नहीं किया.
ठीक करेंगे.
Online में.
Item 37, WPS 6295 of 2014.
But possible. Shadab will not argue the same as when engagement is due to some personal deputy has not come. Only not today.
Not today. Tomorrow?
Yes.
WPL number 6295 of 2014. Counsel for the parties have pressed. Counsel for the petitioner submits that the matter has to be argued by Mr. Sadaf ul Haq,
Yes.
advocate, and on account of personal difficulty, he is not available today. Post tomorrow. Tell.
If possible, day after.
Okay, day after.
Tomorrow I'm not available.
Day after tomorrow in the supplementary cause list.
Item 38, WPL 1464 of 2014. 2015.
Yes, petition. WPL disclosure fee and given a number of subsequent. Yes, petitioner.
Yes, now this is under the payment of gratuity act. The respondent, Srimati Sakina Khatun, is the widow of one Muhammad Quddus.
this Muhammad Quddus was working at a power plant called Loyabad Power Plant, which was owned by Messrs. Bird and Company Private Limited. Now this Loyabad Power Plant was taken over by the Bihar State Electricity Board. And subsequently,
When was it taken over?
dates are
The date is perhaps not available.
it is not relevant. But thereafter, this power plant was transferred to BCCL in the year 1972.
By BACB.
Yes, by the Bihar State Electricity Board to BCCL in the year 1972. Now again this power plant was transferred back to the Bihar State Electricity Board thereafter.
When? What is the time date?
Date
This
is
date
not-
is relevant.
Yes, it may be relevant, but I'll come to that, my lords.
Okay.
Yes. Then, when it was transferred back to Bihar State Electricity Board, 215 casual workers were not taken over, were not retained by BCCL, which resulted in making of a reference to the industrial tribunal that was reference number 27 of 1983. Yes, the tribunal thereafter passed an award directing that they be taken over. Thereafter, the matter comes up before this court. In CWJC number 3486 of 1993R. I'll come to that, my lords. Then the award was set aside by this honorable court. On 14th August 2002. As thereafter, the matter was taken up for arbitration, in which retired Chief Justice of India, Justice V.N. Khare, was appointed as an arbitrator. And the arbitrator's award I have annexed as Annexure 4 to my supplementary affidavit. This is dated 25/5/2009. Before this award could be passed, the workman, Muhammad Quddus, he had already superannuated on attaining 60 years of age on 30th of September 2005. Now let us see the arbitrator's award, which is Annexure 4 of the supplementary affidavit. At page 5. May I place it?
Yes.
Yes. Page 5. Bharat Coking Coal Limited, a public sector undertaking, referred the dispute to me to arbitrate as regards the employment of 177 workers of Loyabad Power Plant claiming employment in Bharat Coking Coal Limited. I accepted the said reference and accordingly issued notice to all the parties, and they are represented by the representatives. Bharat Coking Coal Limited management and the respondents filed their claims, and while the matter was proceeding, the respondents expressed their desire for settlement in the matter during the meeting held on 8th March 2008. The tribunal on the said question passed an order to the effect that the question regarding the settlement of matter is not referred to the sole arbitrator, and therefore the same is not within the competence of the arbitrator. However, both the parties are free to enter into settlement, and the tribunal would not come in their way. It appears that thereafter the respondents negotiated for settlement of the matter, and on 6/11/2008, a settlement was arrived at between the management and the respondents. This settlement has been duly signed on behalf of the management as well as on behalf of the respondents who are parties before me. This settlement was filed on 9/11/2008 before the tribunal. All the representatives of the respondents had admitted their signatures appended on the said settlement. Similarly, the management also accepted their signatures on the settlement. This document is hereby marked as Exhibit A1. The claimant and the respondent both today prayed that the tribunal may give its award in terms of the settlement dated 6/11/2008, which is exhibited as Exhibit A1. In view of the aforesaid settlement made by the claimant and the respondents, this tribunal need not go into the question referred to it for our adjudication. In view of the fact that both parties prayed that my award should be in terms of the settlement, I give my award accordingly. In view of what has been stated above, I give my award in terms of settlement dated 6/11/2008, which forms part of the award. Let us see the settlement, which is Exhibit A at page 7. Loyabad terms of settlement in connection with casual workers of Loyabad Powerhouse of BSEB. Short recital of the case. Loyabad Powerhouse.
His name is also included?
No, the names are not included.
No, the name of the private party was included in the award, this
No.
arbitral award.
No, his name is not there because before this award could be passed
He expired.
or the settlement could be arrived at, he had already retired, superannuated.
But his case was referred,
His case was,
naturally. Otherwise, you cannot refer to this.
yes.
He was at the time. When was the reference made?
The reference was made, this reference to the sole
Yes.
arbitrator.
Yes.
This was made doesn't contain the date of reference. Let us assume that his name was there.
Was referred for arbitration on 8/8/2005. It is there in internal page 2 of the enclosure to the award, second paragraph. And when did he die?
He died
He
on
attained the age of superannuation on 39/2005.
Yes, 30th of September 2000.
So his case was also referred. You cannot say that his case
Yes.
is not referred. Yes, what do you have to say?
Let's say
There is an arbitral award. Did you challenge it?
Because I could not challenge it, my lords.
Then?
Because, my lords, it is a settlement, my lords.
So?
The parties.
Settlement between all the parties who were party to the arbitral proceedings. And your name has ultimately not been, could not have been, you could not have been regularized. It's a case of regularization.
Yes.
Or whatever, absorption. You could not have been absorbed.
My lords,
Because you had
subsequently,
expired.
he has expired, my lords, and wife has, my lords,
You can't do it like this, no? You were already a party to the proceeding. You should have brought it to the notice of the learned arbitrator that one person has expired and therefore some relief should be given to him. Nothing of that sort. And under such circumstances, what relief can be granted to you? What relief could have been granted to you by the learned court? Tell us. This award is binding.
yes.
Then, matter ends. This aspect of the matter has been considered by the learned court.
No, my lords.
So, order is perverse. It has to go. Right?
Yes, my lords.
Okay. So let us see the orders.
Yes. Now, Sakina Khatun, she filed an application before the controlling authority under the Payment of Gratuity Act, saying that my husband has been working continuously and therefore he is entitled to gratuity under the Act. So this was her case. Now we, so far as the employer BCCL is concerned, they contested the matter, saying that before he could be regularized under our service, he had already superannuated, attained the age of superannuation while working under BSCB, and therefore we are not liable to make payment. On that context, this matter was heard before the authority under the Payment of Gratuity Act. I will kindly turn to
Where
page
is your
20.
specific stand that he never worked under you?
Our stand,
You just see internal page 21.
Because this is not their stand, my lords. Yes, my lords.
आप तो पढ़े नहीं है ना, आपको खुद ही नहीं पता कि कोर्ट करेगा आपका काम.
No, yes, I have gone through the But
Then
since
you, at the threshold you said okay, let
No,
it be
yes,
set
because-
aside, being
because
perverse.
in award, my lords, the award is against me, but the finding which is there by the authority, in that finding, my lords, it has been recorded that he was an
Let us see.
employee.
But award is certainly against you.
So on that point, my lords, I am
Let us see, let us see.
yes.
Because when we set aside the order, we have to cite reasons.
Yes. So I am referring to page 21.
Yes.
Top.
Yes.
The opposite party, by the written statement dated 14/5/2012, submitted that Mohammed Quddus, who was actually employee of BSCB and not had been taken on the rolls of BCCL during his lifetime. The opposite party further stated that the above matter was referred to Honorable Justice V.N. Khare, being sole arbitrator before whom the claim of workman for employment numbering 177 of Loyabad Power Plant was referred for adjudication, and before the arbitration tribunal at New Delhi, a settlement was arrived at between the parties on 6/11/2008, and in the said settlement it was consented and made settlement for those who are continuing in BCCA. The Honorable Sole Arbitrator, by minutes dated 25/5/9, has already given the arbitration award in terms of settlement dated 6/11/2008. The opposite party further stated that Mohammed Quddus, casual SDL Mazdoor, was an ex-employee of erstwhile BSCB and had attained the age of retirement on 30/9/2005, and as such he was not on the rolls of the company and cannot be a beneficiary of the aforesaid award dated 25/5/2009, and as such the claim of gratuity is not admissible. So this is our stand.
Let us see further.
Yes,
Read
further. The applicant Srimati Sakina Khatun appeared in person on 9/10/2012 before the controlling authority and adduced her evidence stating that her husband, late Mohammed Quddus, was working as SDL Mazdoor in Sendra Basjora Colliery from 1980 and retired in 2005. Her husband had continuously worked in Sendra Basjora Colliery from 1996, and between 1980 and 1996, her husband had worked sometime at Loyabad Powerhouse of BSEB and sometimes at BCCL Colliery, and died on 26/11/2009. She has 4 sons, namely Shahabuddin, Barkat Ali, Saddam, Samtra Bej, and 2 daughters, namely Sahina Khatun and Samra Khatun. She further stated that she is only wife of her husband, and finally prayed for payment of gratuity amount
So
20.
her case was she was working in Colliery, and at times she was working in the
This is
powerhouse
what,
also.
this is what they say. This is what is the stand taken by them.
That's
Right. Now let us see what is the finding thereafter.
that is you read further. Sri Rajesh.
Yes, I'll
Ranjan.
read it.
Yes.
Sri Rajesh Ranjan, Senior Legal Inspector of Sijua area, also appeared in person on 17/4/2013 and adduced his evidence on oath, stating that Muhammad Quddus, husband of Sakina Khatun, was working in Sindra Basjora as SDL casual Mazdoor and came from the role of BSCB as per arbitration award dated 25/5/2009. Justice B.N. Khare was the sole arbitrator. Arbitrator award had 3 clauses. On 39/2005, he completed 60 years. Arbitration award came into force on 25/5/2009, covering those who are continuing in service as on date of arbitration award. The applicant is not entitled to gratuity, as not covered under the arbitration award, because he completed 60 years on 30th of September 2005. During the course of cross-examination, he stated that it is a fact that Muhammad Quddus was working on and from 1492 as casual labor. He further stated that he is not aware whether Muhammad Quddus worked since 1492 till 39/2005 in BCCL. It is a fact that he was working in Sendra Basjora Colliery as SDL casual Mazdoor. It is a fact that since December 1996 till the date of retirement, he was getting category wages or as per NCWA and other benefits from BCCL. It is also a fact that since 1492 till November 1996, he was getting wages and other benefits from BCCL as per BSCB rate. CMPF deduction was made from the date he came on BCCL roll in December 1996. At the time, his status was casual Mazdoor. In the instant case, the opposite party contended that Muhammad Quddus was a casual employee of erstwhile BSCB with 213 others. There was a dispute in the matter and arbitration award was passed in the matter, and benefits to be given to the such employees to those who continued on the date of award, whereas Muhammad Quddus retired and died prior to date of award, so is not entitled for payment of gratuity. Whereas the submission of the applicant is not that Muhammad Quddus had been continuously serving in BCCL from 1996. He was working at Sendra Basjora Colliery as SDL Mazdoor, and he worked till the date of his retirement. His wages and other remuneration was paid by BCCL management as per NCWA, as per regular employees. The employer deducted his CMPF from 1992 till date of retirement continuously. I am of the opinion that the plea taken by the opposite party is not maintainable, keeping in view the provisions mentioned in section 14 of the payment of gratuity.
You come to the next paragraph.
Yes.
These are just
On going through the submission, this paragraph. On going through the submissions of the parties and documents on record, it is well established that deceased employee was on the roll of BCCL since 1492, as employer themselves have confirmed the deduction of CMPF in respect of deceased employee from 1492, and employer's witness during the course of evidence has also admitted that since 1492 till 96, he was getting wages and other benefits from BCCL as per BSCB rate. It
yes,
is also,
now stop.
Yes.
That should be sufficient. From 1992 to 1996, admittedly he was getting wages.
He got wages as a casual.
Just a moment.
Yes.
The reference when this Loyabad power plant came back to BSCB and the persons were not regularized, the reference was made in the year 1983. Right? The reference was made in the year 1993. The award was challenged in writ petition in the year 1993.
Yes.
And then award was set aside on 14/8/2002.
Yes.
So when the dispute as to whether these persons are to be taken on the role of BCCL was under dispute since 1983, at least since 1983. Then how and under what circumstances you were paying him salary during the period from 1992 to 1996?
These people were working in the capacity of casual workers. Therefore,
it is not your case. Your case was that he was a party. His case was considered under award.
Yes.
And in the award, by that time, he had already expired. It is not your case. That he was never. It is not your case that he is otherwise not entitled. Your case is that his entire claim was through the award.
Our case is that the cases relating to absorption of casual workers went to Justice Khare. And ultimately, a settlement was arrived at for
under what
regularization.
circumstances did you deduct the CMPF and
CMPF has to be
amount, even
deducted.
for casual workers?
It is to be done from every person. Provident fund has to be deducted.
Not from casual workers.
No. Under the provisions of the Act and the scheme, it has to be deducted even for a single day if he works. That is the scheme of Provident Fund.
No, show us that under the Provident, it is not a Provident Fund, it's gratuity. You tell us
this is CMPF.
Payment of Gratuity Act.
Payment of Gratuity Act would be payable.
You see, how do we exactly figure out? He worked in your organization from 1992 to 1996. How do you link him with the award at all?
These people have been working through different employers from time to time. Different employers is initially Burden Company, then Bihar State Electricity Board.
That is not your case. It is not your case that they were employed through some contractor.
No.
The dispute as to whether they are to be at all absorbed was pending since 1983.
Reference in
and rather, you were, the casual workers were not retained by you. They were discontinued, and therefore the reference was made. And therefore, after 1983, where is the question of engagement of this person during the pendency of any litigation at all, till the award was passed, ultimately. And by that time, he had expired.
Yes, these workers were working as casual workers. This is because ultimately, by the award or the settlement award, they were regularized.
The tenor of the impugned order is that he had got nothing to do with that power station. That is the tenor of the impugned.
No, this is, so far as this order under the Payment of Gratuity Act is concerned, the only consideration given is that since deductions were made towards Coal Mines Provident Fund, CMPF, so therefore, he is entitled to receive gratuity under the Payment of Gratuity Act.
Whatever be his entitlement, he will get it.
No, the entitlement would arise if he was a regular workman under the BCCL.
No, but you see the fact that he has been for this period, it's quite a period, 1992 to 1996.
Yes, as a casual worker.
Your entire case was that he was one of the persons involved in the award.
Yes.
And he died during the pendency of the whatever settlement.
Yes.
Right? And therefore there was no occasion for you to regularize him.
Yes.
Right? But that is not his case.
Unless you are regularized, unless these persons are regularized.
It is not his case that he was engaged in Loyabad power plant. It is his case that he worked in the colliery, and then for some time also he used to work in the power plant also, but he was primarily engaged in the colliery. That is his case. You have to show something clinching to set aside both the orders.
No, this is the whatever finding that has been recorded by the authority is not based upon any evidence.
No, that is not your case.
No, there is no exhibit, nothing of that kind. This is based upon the statements,
No,
nothing else.
your evidence has been discussed.
Yes.
It is your evidence. You see, it is your evidence that he was working in Sendra Basjora as SDL casual labor and came from the role of BACB as arbitral award. Right? This is your. He was working in Sendra Basjora. This is a colliery.
Yes, it is a colliery.
It is not Loyabad power plant.
So what the, just I'll read the operative portion once again, then the appellate order also.
Yes.
That's all. Page 22. On going through the submissions of the parties and documents on record, it is well established that deceased employee was on the roll of BCCL since 1/4/92, as the employer themselves have confirmed the deduction of CMPF in respect of deceased employee from 1/4/92, and employer's witness during the course of evidence has also admitted that since 1/4/92 till November 1996, he was getting wages and other benefits from BCCL as per BACB rate. It is also a fact that since November 96 till his retirement, there was no break in service, as no documentary evidence in this behalf has been filed by the employer. The copy of the service excerpt and Form F itself confirmed that the deceased employee was working with BCCL. When it is established that the deceased employee was working in BCCL, the employer has liability to pay his admissible amount of gratuity for the period he rendered service for his employer. It was also observed that since the applicant is the nominee in Form F for payment of gratuity in respect of late Quddus, the employer has also not raised any objection regarding genuinity of the applicant in view of that such. So this is the finding against me. Clear? Then your lordship would see the appellate order. So the controlling authority holds that he was working continuously since 1992 to 96. I have failed to show that there is a break in service after 96, and therefore he continued to work till 30th of September 2005 when he attained the age of superannuation. Now let us see kindly see Annexure 3 at page 27. This is the appellate order. The findings would start from page 28, bottom. Rest are our submissions. Page 28, the last paragraph. On examination of the facts of the case, submissions of the parties, and on perusal of the order of the controlling authority, it has been observed that appellant has denied the payment of gratuity in respect of late Muhammad Quddus on the ground that Muhammad Quddus was a casual employee of erstwhile BACB with 213 others, and there was a dispute in the matter. The said matter was referred to arbitration tribunal, and tribunal passed award as per the terms of the award. The management agreed to regularize the aforesaid casual workers with effect from date of award, provided they have not attained the age of 60 years. And since late Quddus had attained the age of 60 years before the award, therefore, he was not regularized in the service of BCCL. And since he was not the employee of BCCL, he was not entitled to payment of gratuity. On going through the order of the controlling authority and documents filed before him by the parties, it is well established that deceased employee was on the roll of BCCL on 1/4/92. As the employer himself have confirmed the deduction of CMPF in respect of deceased employee from 1/4/92, and the employer's witness during the course of evidence has also admitted that since 1/4/92 till November 1996, he was getting wages and other benefits from BCCL as per BACB rate. It is also a fact that since November 96 till his retirement, there was no break in service, as no documentary evidence in this regard has been filed by the employer. The copy of the service excerpt of Form F itself confirmed that the deceased employee was working with BCCL. When it is established that the deceased employee was working in BCCL, the employer has liability to pay his admissible amount of gratuity for the period he rendered service for his employer. So the controlling authority has rightly passed order of payment of gratuity. In respect of the deceased employee, I therefore do not intend to interfere in the order of the controlling authority. So this
Come
is
to page number 24
24.
of your main writ petition.
24.
Para number 4.
Yes.
Read it.
Para 4. That the Bihar State Electricity Board taken over the ownership of Loyabad Powerhouse from Bird and Company Private Limited. The management and control of the powerhouse was handed over to BCCL in the year 1992. The management and control of powerhouse was reverted to BSEB.
Yes. Therefore, how this person continued to be on your roll after 1992?
Because none of these people were taken
How?
over. Not only him, all these persons, 217 of them, no one was taken over by Bihar State Electricity Board. And that is the reason why they raised this dispute and the matter was referred to Justice B.N. Khare. And ultimately this award has been passed. I'll read it further. The management and control of the powerhouse was handed over to BCCL in the year 1992. The management and control of and powerhouse was reverted to BSEB. At the time of taking back the said powerhouse, there were 216 casual workers on the roll of the said powerhouse. Out of 216 casual workers, 215 casual workers were not taken back by BSEB on the ground that there was an award from the central government in reference case 27 of 1983. That the said award was challenged by the management in the High Court, and during pendency of the writ petition, the management started paying category
This reference was for what purpose? Regularization?
reference was for regular. I'll read the reference order. Whether the demand of casual workmen employed previously by State Electricity Board in Loyabad Power Station, Loyabad Dhanbad, prior to 1/10/80 and taken over by Messrs. BCCL for preference in employment on regular basis, depending upon the number of attendants put in as casual before 1/10/80 is justified. If so, to what relief are the said workmen entitled? So this was the reference. And ultimately, this court set aside the award. So,
The reference was made in 1983.
83 and registered as reference number 27 of 1983.
It is not clear under what circumstances he continued from 1992 to 1996.
No, we have said in this that
मुश्किल लग रहा है. Yes, what do you have to say?
may I just a few more paragraphs, I'll read it. Probably I'll make it clear by reading these paragraphs. Paragraph 4 we have said, we have read. 5. The said award was challenged by the management in the High Court, and during pendency of the writ petition, the management started paying category 1 wages to 136 casual workers, and remaining casual workers were paid consolidated wages. The Honorable High Court set aside the award, holding therein that no employer-employee relationship is created between casual workmen of BSEB and management of BCCL. Thereafter, the management of BCCL stopped them. That thereafter the matter was referred to arbitration tribunal, and the said arbitration tribunal passed his award as per the settlement arrived at between the management and the union. As per the said award, the management agreed to regularize the aforesaid casual workers with effect from the date of award, provided they have not attained the age of 60 years. That late Muhammad Quddus attained the age of 60 years before the award, therefore he was not regularized in the service of BCCL. That thereafter, that after hearing the parties, the
Where is the order of CWJC number 3486 of 1993?
I have a copy of that order.
इसका record मंगाइए. CWJC number 3486 of 1993.
Disposed on
14/8.
14/8/2000.
3486 of 1993.
CW.
R. disposed of on 14/8/2002. आपके पास है ऑर्डर की कॉपी?
मेरा है बहुत फेंट है लेकिन
दिखाइए जरा एक बार। Yes, आपको क्या बोलना?
Yes, my submission is that section 2A of payment of gratuity act speaks about continuous service, and section 4 speaks about payment of gratuity. So as the name of the wife of the deceased employee was there in form of she after his death of the employee filed an application for grant of payment of gratuity. She has established by filing an application, and evidences to that effect were leaded before the controlling authority that this workman, husband of the opposite party, was in regular employment to BCCL from 1992 to 1996. They have rebutted it, management had rebutted it, but they are not able to show that the workman was not an employee of BCCL. It has also been recorded by the controlling authority in the finding that payments were made to the deceased employee. And there was a deduction. The payment which was made is according to NCWA National Coal Waging Agreement, which is entered between the employer and employee.
Finding is that it was being paid as per BSEP rates.
BSEP rates, but was paid by the BCCL.
Yes. Rate was at BSEP rate.
Yes. Now let's do the effect of award, which is passed on 25th of May 2009. There were 3 conditions in the award. First condition.
Mr. Mehta, the list of the employees.
List of employees.
Where is it? Does it contain the name of the ex-employee Mohammed Kudus? When there is a specific number, there has to be a list. As per your case, there were 214 employees, and out of them, you have just mentioned it also.
Yes, in the award, the settlement gives those figures.
It is only just a figure.
Yes, yes.
So, the matter could have been set at rest immediately if the initial list contains the name of the ex-employee.
These are the persons whose names were referred.
That's right.
For arbitration.
That's right.
I do not have the arbitration records.
But you cannot say that you don't have the list.
No, certainly. How can we say? Because the award refers
See, although at this stage there is no question of seeking any further material, but still that list nobody can dispute, both of you, isn't it?
Exactly.
And I'm sure that must be a part of the award also. Because the award has an enclosure as the list of employees. Where is that award?
The award is there. It contains.
No, award passed in this reference case number 27 of 1983.
27. That award I do not have.
इधर record मंगाइए देखते हैं. नहीं तो आपको फाइल करना पड़ेगा. Because.
I'll take back that. I'll give a fair copy as
No,
well
no,
as
this is not sufficient. We'll find out if there is anything
Yes,
in
I'll
the
just-
records.
I'll track.
अगर order sheet के अलावा कुछ नहीं है, तब तो
हाँ.
हम लोग कुछ कर नहीं सकते. Then I will pass the order accordingly to the best of my wisdom. Right? Because इस वक्त बहुत मुश्किल
हमारा
है कोई
केस
supplement किया.
छोटा सा था. Your lordship is also right कि 1983 से 1992 और 92 से till the date of his retirement, my witness is saying
Yes.
that he was working but getting wages of BSc.
Yes.
But
he was working in the colliery.
He was working in a
The colliery. This
Yes.
is also
Because
very
what
different.
happened, I'll tell your lordship, what happened when this plant went back and they refused to absorb these persons, we had engaged these persons in some collieries. So that is how. from
And all the entries made in your statutory registers, you had also made certain payment on his behalf.
Yes, we have made certain
So
payments
therefore-
also.
So therefore,
But,
under such
Not
circumstances,
only him, but others also. Anyway,
Master,
we'll see.
we are
my
not
lords.
concerned with others. They have not come up before us. They have actually been regularized. So therefore, there was no occasion for them to come. They must have got the benefit under the Payment of
Certainly,
Gratuity Act
once
also.
they are regularized.
They are entitled to everything. ये जरा रिकॉर्ड मंगाइए, सेकंड हाफ में लिखाएंगे, आ जाइए. ये भी नहीं करेंगे, उसका बहुत दिक्कत है. Your junior can be here.
I'll come back. If I don't have work, I'll come back.
Item 32, WBC 65/6 of 2022. Passport case. 226.
यहीं पर होगा, नहीं होगा ना. WPC number 6566 of 2022. The learned courtmaster has reported that this matter has been wrongly listed before this bench. Office is directed to place this case before appropriate bench as per roster.
Item 39, WPL 1482 of 2016.
I'm seeking a short indulgence. Even if this matter is posted tomorrow, we can argue the matter. The only issue is that the file was left behind on the last date. I was not in possession of the file. That's why I'm seeking only one indulgence. I'm ready with the judgments. I'll prepare a short list of dates.
I want to know where is your second show cause reply? कहाँ है record पे बताइए? आपका second show cause reply कहाँ है? Is it there on record, madam?
Your Lordship, we had issued the notice to him on 29/3/2006, and thereafter he had appeared before them, before us,
The
on
second so-called
29/3/2006.
Second
for
so-called notice
hearing
has
on-
been issued, my lord, without enclosing the inquiry
That is
report.
why, but you responded to it.
Yes.
Where is that response? उसी से पता लग जाएगा आपका इंक्वायरी रिपोर्ट मिला है कि नहीं मिला है, आपने इंक्वायरी रिपोर्ट का डिमांड किया है कि नहीं किया है, क्या किया है.
In relation to that extent, in the award itself,
Inquiry
he has
report,
filed an application
second
before the
so-called notice के
industrial,
साथ
before the
enclosed
learned
नहीं.
tribunal,
I have
saying
al-
that all the principles of national justice
I
were
have
met.
objected the filed application to.
If paragraph,
The proceeding was held to be fair and proper.
yes, if page 78 of the writ petition will be seen, the findings with reasons, para 6, it is clearly mentioned that he has filed a petition before the tribunal. If I may
Saying
permit
that
you
it
to
is
read-
fair and
Yes,
proper.
if I
Where is
permit
it?
two lines.
Where is
Page
it?
78 of the writ petition, para 6.
Yes.
At the preliminary point, the workman, as per his petition dated 19/7/2013, has accepted the domestic inquiry as fair and proper. Accordingly, the tribunal, as per order number 29 dated 21/1/2014, held the domestic inquiry as fair, proper, and in accordance with the principle of natural justice.
This, my lord, the inquiry
has not been said, my lord, to be fair and proper by the inquiry officer, my lord, not by the disciplinary authority, my lord, not even by the appellant authority, my lord. Since
Then why
matter
did you
is
file a
being
petition?
since matter is being delayed, my lord, the respondent number 2 said that inquiry is fair and
So
proper.
therefore, you have suffered whatever you had stated. There was no occasion for the award for the Labour Court to enter into the issue as to whether the inquiry was fair and proper or not.
And,
Normally, it is decided as a preliminary issue and upon contest, isn't it? You never contested it.
in preliminary inquiry, my lord, the petitioner has not been consulted, my lord. And on the basis of
You will deny this.
My lord,
How? Did you engage somebody, or you were appearing yourself? The workman was appearing himself, or he had engaged somebody?
my lord,
Yes.
award has been granted on the basis of quantum of punishment, my lord. The allegation against the respondent number 2.
Don't shift from one point to another. Did you file a petition that the inquiry was fair and proper?
I have filed a petition before the tribunal, my lord, because matter was being delayed, my lord, since the petitioner.
So where are you saying this?
But not disciplinary authority might said the inquiry is fair and proper, my lord. Not appellant authority said.
But
so.
you have to suffer whatever you have stated before the learned Labour Court. This was your specific stand, that it was fair and proper. Then the only thing with what was required to be seen is primarily the quantum.
My lord, disciplinary authority, my lord, did not say anything about
Did not. Did the disciplinary authority say that it was not fair and proper?
Nothing has been whispered about this, my lord.
So under that circumstances, what can be done about it? You have not even challenged this order. Did you challenge this order? Order dated 24/1/2014. Did you challenge it?
The petitioner challenged the order of disciplinary authority before the appellate authority, my lord. Appellate authority said, my lord, that nothing to be here.
सर ऐसा है ना कि क्वेश्चन को डॉज करने से सॉल्व नहीं होता, वो खड़ा रहता है वहीं कभी.
But appellate authority, my lord, did not give opportunity to the respondent number 2, my lord. It has come in the order of the appellate authority, my lord.
All the materials are on record.
Yes.
Page 62 may kindly be seen, my lord. The order of the appellate authority, my lord.
You will not see that. We'll call for the records. Records have come? इसका records आया? Okay, WPL number 1482 of 2016. Counsel for the parties are present. Counsel for the petitioner has submitted that in paragraph 6 of the impugned award, it has been categorically mentioned that it was the respondent who had accepted that the domestic inquiry was fair and proper, and accordingly the tribunal, as per order number 29 dated 24/1/2024, held that the domestic inquiry was fair and proper and in accordance with the principles of natural justice. The learned counsel submits that neither the order dated 24/1/2014 was ever challenged by the respondent, nor he has submitted that the order order number 29 dated 24/1/2014 was never challenged by the respondent, and accordingly the learned tribunal learned Labour Court,
Yes.
learned Industrial Tribunal
Industrial Tribunal number 2 at Dhanbad.
Learned Industrial Tribunal number 2 at Dhanbad had to primarily confine the adjudication with regard to the quantum of punishment. And within the parameters of section 11 capital A of the Industrial Disputes Act. Let the records be called for from the concerned court, concerned tribunal. Let this order be communicated to facts. Record आने दीजिए. सुनने के बाद फिर कोई चीज़ का जरूरत होगा तो it is very difficult. Also for the respondent is present. उसको एक तो date दे देते. बताइए when you want.
Any date.
24th July for final disposal. If you want to see the records, you can ask the court master. You can give a slip, but on next date you do it. आप लोग दोनों को record मिल जाएगा यहाँ से देखने के लिए, कोई दिक्कत नहीं है. Just have a look at the record. 11A का scope देखना होगा.
Item 40, WPO 6387 of 2016.
Yes, petitioner.
Leadership इसमें call for LCR report हुआ था, report अभी तक आया नहीं.
Records have not been received. By which order the records were received, were called for? By which order?
I've been instructed by my senior that there will be call for record, so I've not gone through the case properly.
Who is your senior?
PS Pati, Mr. PS.
All the orders are uploaded. Have you seen it? Who will do that homework for you? Mr. P.S. Pati is a very busy counsel. He doesn't have time to see the records. I just want to know from you. But where the records call for? Never. कुछ भी बोलते. All the orders are uploaded orders, right? Yes.
LCR has not been received.
There was no direction to call for the LCR. दीजिए भाई. घर पे नहीं पढ़ते यहाँ पढ़ाइए उनको. Give the file.
After 5 years of the order, this writ petition is filed here.
You just give him that. पढ़िए. बताइए कौन से ऑर्डर से रिकॉर्ड कॉल फॉर हुआ था जो नहीं आया अभी तक. पास होगा नेक्स्ट केस कॉल करें. 5 मिनट बाद 12:15 में टेकअप करेंगे. बताइए कौन से ऑर्डर के साथ से रिकॉर्ड कॉल फॉर हुआ.
Item 41, WPL 1530 of 2017.
तो नॉट बिफोर नहीं होगा. मेरे ऑफिस में कैसे यहाँ पे कैसे लिस्ट है? नॉट
Item 42, WPL 5587 of 2017.
मैडम को बता दीजिएगा नॉट बिफोर नहीं का ऑर्डर कैसे.
May please not. This is the case for person the annexer 7 matter. In this case, the award was granted to opposite party matter. Notice was issued by the notice. The 3-4 एक case को notice.
तो क्या हुआ?
तो so cause file ऐसे.
नहीं appear हुआ नहीं हुआ. बस.
I am reading.
You are appearing. Argue.
Yes.
You have entered file वकालतनामा.
We have filed वकालतनामा. We will file a counter.
Counter. Counsel for the parties are present. Counsel for the private respondent.
Yes.
Respond number 2.
Sanjay.
2.
Yes, my lord.
Gomdi Rao
Rao.
seeks adjournment to file a counter affidavit. When do you want?
After 3 weeks, any day.
Post this case on 24th of July 24 under the heading for final disposal. Office is directed to call for the records from the concerned court. Record मंगाइए. Counter से कुछ नहीं होता है ऐसे, right? From the court of learned presiding officer, Labor Code Devghar, relating to WC case number 28 of 2011, decided on 22/6/2017.
Item 43, WPS 6968 of 2017.
Yes, petitioner.
So the issue is covered by your lordship's order. Similar case was not entertained by your lordship. Only the interest portion was modified, holding that under 33C2 interest cannot be awarded. It is a similar case where your lordship, in an accident, a person died. We said it is not a mine accident, but that argument has been negated by your lordship. With that order we had complied, it has appealed penalty.
This is appeal penalty.
Para 27
Have
and
you shown the order? Para number?
27 and 28 lordship has discussed regarding interest.
Okay. WPL number 6968 of 2017. Yes, madam, have you seen this order?
I'm looking for.
The interest portion has only been interfered with.
My lord, as per this order, my lord was on.
The learned counsel for the parties are present. This petition has been filed for the following relief. The learned counsel for the petitioner has submitted that so far as the merit of the case is concerned, the petitioner is not contesting the same in view of the fact that okay, the learned counsel for the petitioner has fairly referred to order dated 19/6/2023 passed in WPL number 6969 of 2017, and he submits that the present case is squarely covered by the said judgment. The learned counsel has further submitted that this court has interfered with only in connection with the payment of interest. He has referred to paragraph 27 to 30 of the aforesaid judgment. The learned counsel appearing on behalf of the respondent number?
Respondent number 1.
Respondent number 1 has submitted that
I should say respondents.
Respondent number 1. Respondent number 1 has submitted that the present writ petition be disposed of in terms of WPL number 6969 of 2017. बाकी तो कुछ ड्रॉ करना ही पड़ेगा ऑर्डर. That I will do the needful, right? These documents are there, annexure 2 वगैरह सब फाइल किया. Same order as this. ये कौन, हम तो भूल गए, हमको नहीं याद. मुकुल जी का ऑर्डर है, ये ले लीजिएगा उनसे, ठीक है?
Item 44, WPL 7038 of 2017.
Yes, petition. Yes.
लॉर्डशिप, ये रीड पिटीशन टाटा मोटर्स वर्कर यूनियन के लीगलिटी एस्पेक्ट को लेकर के सवाल या निशान खड़ा करता है। टाटा मोटर्स वर्कर यूनियन, जिसको प्रीवियसली टीएमएल ड्राइवलाइन वर्कर यूनियन के नाम से जाना जाता था, ये टीएमएल ड्राइवलाइन एक लिमिटेड कंपनी की वर्कर यूनियन रही है। टाटा मोटर्स लिमिटेड के वर्कर यूनियन,
Who all are the parties before us? Who is appearing for Tata Motors? TML Driveline Limited. Who is it representing? Are you there? Okay. And then respond number 6. M.N. Rao, President.
For the union, my lord, since the instant petition was earlier dismissed for default, it was subsequently restored by the petitioner, my lord, so filing the CMP, my lords. But I was, my lords, paying for some time, my lords, for seeking instructions so far as point number 5 and 6 are concerned. We will be filing, my lords, fresh wakalatnama and counter affidavit in the matter.
One more information.
What is this?
This is actually, my lords, a frivolous litigation.
Tata Workers Union, all the cases
But
are
what is the locus, if I may argue, my lord, though we have...
Who is he?
They are no one. What is the prayer? Kindly have a look at the prayer. How is it this prayer possible? But there are two unions. Telco Workers Union is one of the union with Tata Motors, and we are the other union, my lords. Now our name has also changed, TML Drivelines Limited. Now what is the prayer, my lords? Kindly see. For issuance of a writ in the nature of certiorari for quashing of the order number so and so dated so and so, issued by additional registrar trade unions Jharkhand, whereby and whereunder the objection submitted to by the petitioner to the proposed amendment in the constitution of TML Drivelines has been rejected. For issuance of an appropriate writ so and so, for quashing of so and so, issued by additional registrar, whereby and whereunder approval has been given to the proposed amendment in the bylaws of TML Drivelines Workers Union to the extent it relates to allowing the said union to offer membership to the workers of Tata Motors Limited in addition to the workers of TML Drivelines Limited and for so and so. So my trade union guide constitution of bylaws has been amended. What objection can he have?
लॉर्डशिप,
What is the locus?
टीएमएल ड्राइवलाइन लिमिटेड की वर्कर यूनियन टीएमएल ड्राइवलाइन वर्कर यूनियन रही है, जिसका मर्जर बाद में 2018 के बाद में टाटा मोटर्स में हो गई है। टाटा मोटर्स की ऑलरेडी एक ट्रेड यूनियन रही है जिसको टेलको वर्कर यूनियन रही है। टीएमएल ड्राइवलाइन के एम्प्लॉय का मीटिंग के तहत में अपने बायलॉज में ये चेंज किया गया, अमेंड किया गया कि वो टाटा मोटर्स के वर्कर को भी अपने साथ मेंबर बना सकते हैं, जबकि उस पर्टिकुलर मीटिंग में टाटा मोटर्स के एक भी एम्प्लॉय वहां के वर्कर मौजूद नहीं थी। ये टीएमएल दो अलग अलग सेपरेट कंपनियां हैं लॉर्डशिप। टीएमएल ड्राइवलाइन लिमिटेड अलग कंपनी है और टाटा मोटर्स लिमिटेड अलग कंपनी है। टीएमएल ड्राइवलाइन
मर्ज कब हुआ?
मर्ज 2018 में हुई है एनसीएलटी के आदेश पर। बट प्रीवियसली इसके पहले वो एक आदेश को लेकर के जो एडिशनल रजिस्ट्रार के यहाँ पे सबमिट किया गया और उसके अमेंडमेंट को चेंज करने के लिए उन्होंने परमिशन ग्रांट किया कि वो अपने बायलॉज में चेंज कर सकती हैं, जिसके सपोर्ट में
One important, very important point, your ladyship, that it has deregistered and that matter is pending before Patna High Court.
Deregistered. What has been deregistered?
Petitioner has been deregistered by the government of Bihar. Now they filed a writ petition in Patna High Court, which is state, but they have also been in the meantime de-recognized by Tata Motors Limited. So all these facts have to be brought on record. Your lordships have seen it is a kind
Deregistered, it must be because of the fact that post bifurcation, no application must have been filed, no formal application. There are so many deregistration of trade union, cooperative societies. It must be one of those.
So that is the reason. So that has not been reinstated. Plus they have probably applied here, which is pending. But all I want to say is, your lordship gives us, if your lordships are satisfied, that is a case which should go on, because my learned friend must first point out the locus.
No, his entire cases that the Tata Workers Union and this Tata Workers right?
Telco workers and TML drivelines.
Right. So far as Telco Workers Union and Tata Motors is concerned, they have their own list of workmen. But so far as this TML Driveline Limited is concerned, they could not have entertained the workers of Tata Motors Limited to be their members.
I have a simple answer. There are trade unions at India national level, Intucan, etc. Every company's workman can become a member in that. Where is the bar?
Is there any legal requirement? Just a moment. Show me some legal provision that a person who is not belonging to that company cannot become a member of that union.
Second point, my
No, first point पर हैं अभी. Second point तक नहीं पहुँचे. You show me from the Trade Union Act or from some provision that any person who is not an employee of the company cannot become a member of the union. इतना satisfy कर दीजिए, कहानी खत्म हो जाए. बस इतना ही तो है. Yes, counsel. Is there anything more?
लॉर्डशिप पूरी बात थोड़ा सा बोलने का मौका दिया जाए.
आपको पूरा मौका है. बोलिए क्या बोलना.
लॉर्डशिप इस पूरी की पूरी कहानी में ये दो सेपरेट कंपनियां हैं लॉर्डशिप. एक टीएमएल ड्राइवलाइन है, एक टाटा मोटर्स है. टीएमएल ड्राइवलाइन के वर्कर यूनियन का मीटिंग में ये बात का तय किया जाता है कि वो टाटा मोटर्स के एम्प्लॉय को भी अपने यहाँ मेंबर बना सकते हैं. और ये बात का अमेंडमेंट, इस बात का एप्लीकेशन को एडिशनल रजिस्ट्रार ट्रेड यूनियन के यहाँ एप्लीकेशन दिया जाता है और इसके लिए ऑब्जेक्शन रेज किया जाता है टेल्को वर्कर यूनियन के द्वारा, किया जाता मेरे ट्रेड यूनियन के द्वारा. लेकिन ऑब्जेक्शन को साइड करके इसके अमेंडमेंट को ऑर्डर को पास किया जाता है. ऑर्डर डेटेड है लॉर्डशिप.
उसमें इलीगैलिटी बताइए ना, क्या इलीगैलिटी
आ रही है.
इज देयर एनी लीगल बार?
आ रहे लॉर्डशिप. उसके बाद अमेंडमेंट में मेंबरशिप, सेकंड पॉइंट ये है कि मेंबरशिप के लिए ऑफर दिया जाता है, मेंबरशिप किया जाता है. लेकिन जिस डेट को टाटा मोटर्स के लिए रजिस्ट्रेशन फाइल किया जाता है तो वो सेक्शन 4 में क्लियरली शो किया गया ट्रेड यूनियन में कि एटलीस्ट 10% और 100 मेंबर्स उस कनेक्टेड कंसर्न कंपनी में एम्प्लॉई या वर्कमैन होना चाहिए एप्लीकेशन रजिस्ट्रेशन एप्लीकेशन देने के दिन में. तो जिस डेट को ये एप्लीकेशन फाइल कर रहे हैं टीएमएल ड्राइवलाइन वर्कर यूनियन, उसमें सिंगल एम्प्लॉय भी टाटा मोटर वर्कर यूनियन के सदस्य वर्किंग नहीं रहे.
प्रोविजन बताइए, ऐसा नहीं हमको आपकी बात नहीं समझ.
सेक्शन 4 लॉर्डशिप,
ट्रेड यूनियन एक्ट,
ट्रेड यूनियन एक्ट सेक्शन 4.
पहले तो आप हमको ये बता दीजिए, एटलीस्ट वी आर ऑन द सेम पेज टू द एक्सटेंट दैट देयर इज नो लीगल बार दैट अ पर्सन working in one company cannot become member of a trade union of another company.
I accept it, lordship, but application registration for application के लिए ये provision section 4 में दिया गया है.
Let us see. Section 4 is what? Amendment or main application?
Provided mode of registration section 4 provided that no trade union of workmen shall be registered unless at least 10% or 100 of the workmen, whichever is less, engaged or employed in the establishment or industry with which it is connected are the member of such a trade union on the date of making of an application for registration. But on that date, not a single workman are the employee of Tata Motors Limited. They are the employee of TML Driveline Limited, lordship.
This is just an amendment in the
lordship.
In the bylaws. This is not the registration of the trade.
Once एक minute.
Okay, this is just an amendment. Your objection has been rejected.
Yes, lordship.
Where is that rejection order? Show me the rejection order. He must have discussed it.
That is page 67, I think.
बताइए. Where is the order of rejection?
Page 67, that is 28/10/2016.
This is absolutely non-speaking, पता नहीं. But where is the detailed order?
It is said आपको भेजी जा चुकी है 17/10 is the next page, which is the approval. But
That
my
is
point is, where is
approval.
the procedure or the locus for us to intervene?
No, that is another thing. But when there is an order, let us see.
This is the
where is
communication
order.
that we have rejected it and it has been approved. All they are saying is that we
Page
have.
number 69 is what?
Page number 69 is Milord's Sanchita Sankhya Sanshodhan. So this is Milord's the note sheet. Note sheet.
Page number 74 में आएगी.
Annexure 8.
मेरे पास है ही नहीं, मेरे पास जो कॉपी है ही नहीं.
74 में आएगी.
28/10/16.
नहीं, पेज नंबर 69 में आई है, Annexure 9. सर्वप्रथम पढ़िए आप. 69 पढ़िए. 74. Read it please.
विषय टीएमएल ड्राइव लाइन वर्कर यूनियन निबंधन संख्या 211 टी10.
नहीं, उसके ऊपर सर्वप्रथम इस आवेदन से स्पष्ट है. पढ़िए. जस्ट उसके ऊपर. मिला कि नहीं मिला? पेज नंबर 74 में है आप.
69.
सर्वप्रथम इस आवेदन से ये स्पष्ट होता है कि महामंत्री निबंधित यूनियन द्वारा किसी नए निबंधन के अनुरोध नहीं किया गया है. साथ ही आम सभा में उपस्थित सदस्यों की संख्या 1000 से ऊपर रखा है तथा यूनियन द्वारा वर्ष 2014 एवं 2015 में वार्षिक विवरणी जमा किया गया है. टीएमएल ड्राइवलाइंस वर्कर्स यूनियन निबंधन संख्या इतना कि महामंत्री द्वारा समर्पित आवेदन पत्र जो उनके साथ संलग्न अभिलेख से स्पष्ट होता है कि संविधान संशोधन हेतु दिए गए आवेदन में प्रावधानित व्यवस्था की अनुरूप नियमों का पालन करते हुए आवेदन दिया गया है, परंतु उक्त आवेदन के विरुद्ध श्री अभय कुमार सिंह अन्य द्वारा आपत्ति उठाई गई है तथा शिकायत की गई है. अतः इसकी जांच पड़ताल से कर संतुष्ट मंतव्य के साथ प्रतिवेदन भेजने हेतु उप समायुक्त जमशेदपुर को निर्देश दिया जा सकता है. एतत् संबंधी पत्र के प्रारूप की संविदा पर रख दी गई है. प्रस्ताव एवं प्रारूप पर निबंधक श्रमिक संघ झारखंड का अनुमोदन प्राप्त
Now
किया.
you come to page number 77 and ultimately where is the decision?
On his application.
Huh?
Because I do not have these pages. Let me have a look at these pages. My brief which I got after 72 it does not have.
77 page number lot की.
आपका ऑब्जेक्शन रिजेक्ट किया पेज नंबर 77 में. इसी में इलीगैलिटी बताइए क्या. They must have dealt with your point, isn't it?
But lordship, LPA 456 में इस डबल बेंच यहीं के ऑनरेबल हाई कोर्ट के ये बात को क्लियरली शो किया गया है कि ट्रेड यूनियन अपने कॉन्स्टिट्यूशंस में structure of the union shall not be changed under any circumstances.
कहाँ है जजमेंट दिखाइए.
Last page.
The learned counsel for the parties are present. Counsel for the petitioner has submitted that the impugned orders have been challenged on the ground that the additional registrar trade union Jharkhand had allowed amendment in the constitution of TML Driveline Workers Union by enabling the members of Telco Workers Union to be members of the state union. He submits that such amendment has the effect of changing the constitution of the trade union and therefore such amendment would not have been allowed. यही आपका case? The learned counsel has relied upon a judgment passed by this court in LPA number 456 of 2017.
एक और citation है, ruling है जो ऑनरेबल हाई कोर्ट के द्वारा दिया गया, पॉइंट नंबर 6 लॉ।
The learned counsel has also relied upon order passed by this court on date of order. Order passed by this court in LPA on 8th of August 2023 in LPA number 82 of 2022 and has relied upon paragraph 6 thereof. Counsel for the respondent seek adjournment by stating that there has been subsequent developments during the pendency of this case and they need to file supplementary counter affidavit for this.
Counter, we are not fighting.
Lordship, again एक escort इंडिया लिमिटेड का citation भी है जिसमें section 4 को लेकर के बोला गया।
The learned counsel has further relied upon a judgment passed by this court. By this court? By the Honorable Supreme Court of India, reported in bracket 2017, bracket close 16, SCC 366, decided on 14/9/2017. उन्हीं के submission में लिख दीजिए. Learned counsel for the respondents are directed to seek instructions and file a counter affidavit in the present case. फाइल कर दीजिए आप काउंटर. This is what his entire case is.
Right? One more thing I want to.
आप क्या बोले?
इन्होंने ये बात बोले कि मेरा ट्रेड यूनियन का रजिस्ट्रेशन कैंसिल है, तो इस संदर्भ में हालांकि ये इस मैटर का नहीं है लॉर्ड, बट इस संदर्भ में सुप्रीम कोर्ट ने पहले ही आदेश दे रखा था कि अपना टेन्योर अगस्त 2018 को कंप्लीट हो रहा है, तो री इलेक्शन एलपीए के संदर्भ में एलपीए के डिसीजन के बाद किया जा सकता। एलपीए 455 में 456 में वो टाइम बार दिया हुआ है लॉर्डशिप, इलेक्शन कंडक्ट
वो इनका ऑब्जेक्शन आएगा तो उसका रिस्पांस में डाल दीजिए, ठीक है? और जो आप जजमेंट रिलाई करना चाहते हैं अपने रिस्पांस में फाइल कर दीजिएगा, ठीक है? बताइए कितना टाइम चाहिए आपको काउंटर फाइल करने? The counter affidavit be filed by
3 weeks.
Okay. By 10th of July, all of you.
10th of July.
Okay. Rejoinder by 24th. Yes, counsel. By 24th. Post on 31st of July. ये फ्रेश फाइलिंग में है अभी भी एडमिशन.
Password case item 40.
Yes. By which order the records were called for?
There is no such order regarding PCR.
Yes. What is your case? Argue. You want to argue?
Just I've been instructed to appear and say that PCR has not been received.
आपके सीनियर आ गए, चेंबर में नहीं सिखाते हैं, इसलिए कोर्ट में सीखना पड़ता है. सारे ऑर्डर्स अपलोडेड रहते हैं. प्रॉब्लम पता है क्या है मिस्टर पति? व्हाट इज एग्जैक्टली हैपनिंग? जूनियर्स का गलती नहीं. आप उनको पहले से तो बताते नहीं होंगे शाम को कि भाई ये केस तुम देख लेना. अब इधर उधर दौड़ रहे हैं, उसी में चले जाओ कोर्ट में. दिस इज व्हाट इज हैपनिंग, और यहाँ पे डांट पड़ती है। तो उन लोगों को इतना अभी तक नहीं समझ आया है कि नेट में तुरंत देख लें कुछ सबमिशन करने के पहले। कैसे चलेगा? अगला जनरेशन को नहीं तैयार करना है। हाँ, they will not know how to do the cases. No, no, आपकी गलती नहीं, आपके सीनियर आ गए हैं डांट सुनने के लिए। ऐसा नहीं कर, रिकॉर्ड्स की कोई जरूरत नहीं, बताइए क्या करना है।
Records should be my submission because the 7A proceeding says that the relevant documents were not put. The tribunal gives a specific find that all documents are there on record, so there was no requirement of initiation of any 7A proceeding. So that is a finding of that will be, if the documents are there, my lord, then it is either of the finding is purpose, either the 7A or the tribunal finding.
Where is the finding of the tribunal?
Yes, it's a 2-page finding, my lord. Para 6, page 43. The
Yes.
The applicability of EPF Act to the appellate establishment is not questioned. Para 2F defines the word excluded employees. Then the finding, the definition makes it clear that the person who had withdrawn all the benefits and the person whose pay and DNS allowance exceeds rupees 6,500. In this case, the salary register, income tax return and balance sheet reveals that these persons were receiving wages more than 6,500. So assessment for these persons cannot be termed legal. Now, may I place the 7A order, my lord? 7A order starts at page 39.
39.
Finding. Page 39. After going through the proceeding record petition reply submitted by the establishment, the report of the departmental representative having applied my mind, it is found that the case is mainly concentrated on the issue regarding grant of benefits to the establishment in respect of wages of salary paid to excluded employee who were drawing more than 6,000 per month. It is observed that the salary of the excluded employee were always rupees 1 lakh and above in every financial year, which liable the employer to deduct income tax from the salary and deposit it with the income tax department, followed by submission of prescribed return for non-production of this valuable quarterly return by the establishment, taking shelter of its being 6 to 7 year old cannot be accepted. This is because as per IT Act rules, record relating to minimum 7 years is required to be preserved. The explanation of the establishment, evidence that the employer has failed to deduct income tax from the salary, has not complied with income tax department or has prepared fake salary register to evade grant of membership under PF. In this way, the request for establishment fails, which was heard as per direction of this Honorable High Court. So the 7A records that despite time he did not produce the relevant records.
No, it is not there. It is not saying that despite time you did not produce the relevant records.
I will read from the other one.
Yes. Where is the order of the High Court?
Remand order is at page 37, 38.
Let us see the remand order.
In paragraph, the main grievance of the petitioner is that though the proceeding was conducted to assess as to whether the petitioner's establishment is liable to pay any dues under provisions of section 7 of the Act, but the proceeding was not conducted in accordance with the rules and principles of natural justice, nor was the petitioner afforded adequate opportunity to defend the proceeding. To demonstrate, Sri Anil Kumar Sinha, senior counsel for the petitioner, invites attention to certain paragraphs of impugned order and submits that even as per the impugned order, though on representation of the petitioner he was called upon to submit the statement other documents in defense, and even though the petitioner has availed the opportunity to submit all required documents on basis of which the decision regarding the assessment has been made out, but the final decision on issue was taken by the respondent assistant PF commissioner on basis of reports submitted by the departmental representative, and that too without serving a copy of such report upon the petitioner and without enabling the petitioner to raise objection, if any, in respect of the purported adverse statement contained in report of departmental representative.
Kindly pause. The case of this Bravo security was that he had produced all the documents, but the entire order was passed on the basis of a report and he was not given an opportunity to respond to the report. Right? So it is not a case that the documents were not produced and not
Pursuant thereafter this order.
and further. Yes. Then para number 6.
Having perused the impugned order and the facts and circumstances of the case, this court is satisfied that the stand taken by the learned counsel of the petitioner is correct. It does appear that even though the final decision on the issue raised before him was taken by the assistant PF commissioner on the basis of a report which the departmental representative was asked to submit, but neither a copy of such report was served upon the petitioner nor any hearing conducted on basis of the report to enable the petitioner's representative to submit his defense in the proceeding. Considering the aforesaid fact and circumstance, I find merit in this writ application. Accordingly, the same is allowed. Because the report of the departmental representative was not served and that material was used. For that reason, the order was filed.
Now the fresh order, Annexure 5.
Yes. May I place the order?
Yes.
Shri S.K. Singh, Manager HR, appeared to represent the establishment. Shri R.R. Pandey, Enforcement Officer, appeared on behalf of the department. Later, Shri L.S.B.P. Sinha, Enforcement Officer, represented the department. The establishment was asked to submit appointment letters in respect of all excluded category of employees, copies of Form 16 issued to such workers, TDS sent to Income Tax Department year-wise, payment register, salary statement for the notice period, copy of agreement work order of the parties where they were deployed. On 16/2/2009, Shri Singh submitted a letter requesting for supply of reports submitted by the squad of the enforcement officer and departmental representative, which was basis of determination which was made available to him. On 23/2/2009, Shri Razi Hassan appeared on behalf of the establishment. He produced salary register of excluded employees for the period 1/03 to 6/04 and 1/05 to 6/07, balance sheet for 0304 and 0405 along with IT returns. Later, the establishment submitted one petition dated 19/5/2009. Shri L.S.B.P. Sinha, Enforcement Officer and Departmental Representative, was directed to go through the petition and submit his comment and submit his report on 9/6/2009. Shri Sinha filed his report dated 9/6/2009. A copy of the same was sent to establishment. Shri Razi Hassan and Shri Jaya Ranjan appeared on 23/6/2009. He submitted reply dated 26/6/2009 on verification report of departmental representative. As above, the case was closed and order was reserved. Finally, after going through the proceeding, records, petition, replies submitted by establishment and the report of the departmental representative having applied my mind, it is found that the case is mainly concentrated on issue regarding grant of benefit to establishment in respect of wages, salary paid to excluded employees who were drawing more than 6,500 per month. It is observed that the salary of the excluded employee were always rupees 1 lakh and above in every financial year, which liable the employer to deduct income tax from the salary and deposit it with the income tax department, followed by submission of its prescribed return. For non-production of these valuable quarterly returns by the establishment, taking shelter of its being 6 to 7 years old cannot be accepted. So he did not produce the quarterly returns regarding the TDS deductions. This is because as per IT Act rules, records relating to minimum 7 years is required to be preserved. The explanation of the establishment evidences that the employer has failed to deduct income tax from the salary and has not complied with the income tax department or has prepared fake salary register to evade grant of membership under PF scheme. In this way, the request of the establishment fails, which was reheard as per direction of Honorable High Court. Accordingly, the dues under Section 7 of the Act assessed previously, that is rupees 28,78,215, by order dated 24/3/2008, is to be taken as the due and interest under Section 7(2), and interest under 7(2) needs to be quantified as on date. Thus, the establishment is required to deposit the dues in the following manner.
So you are defending this order.
Yes.
Now it is 6,500 per month and above.
Above will be
And
excluded.
now he has given the definition of excluded employee,
Yes.
which says exceed 5,000 rupees per month. Read it.
And employee
Yes.
excluded employees mean an employee who having been a member of the fund withdrew the full amount of his accumulation in the fund under clause A or C of F subpara 1 of paragraph 69. An employee whose pay at the time he is otherwise entitled to become member of the fund exceeds 5,000 rupees per month. Pay includes basic wage with dearness allowance, retention allowance, if any.
So therefore, excluded employee, if he has a salary more than 5,000 rupees, he's an excluded employee.
Yes, that has changed with time.
So maybe it has changed,
but
this is the definition at the relevant point of time. And then it simply says that these persons were drawing salary more than 6,500 as per the IT returns, etc. And therefore they were not to be included.
But that the authority says that he has not produced the income tax TDS certificate and all those things.
Your specific case was a specific case that these employees were drawing a salary more than 6,500.
But the authority says that if they had it been a case that they were drawing more than that, there should have been income tax deductions, TDS ought to have been done.
They have said that this, it was there. It is observed that the salary of the excluded employee were always rupees 1 lakh and above
Yes.
in every financial year, right?
As per the claim of the establishment, this was the claim
No,
of the
no, it is
establishment.
observed. No, you just read the findings.
Yes, that is the establishment claim.
Yes, yes, you read it. After going through the proceedings, records, petition, read it, please.
Yes, after going through the proceeding record, petition, replies submitted by the establishment and the report of the departmental representative, and having applied my mind, it is found that the case is mainly concentrated on the issue regarding grant of benefit to establishment in respect of wages, salary paid to excluded employees who were drawing more than 6,500 per month. It is observed that the salary of the excluded employees were always rupees 1 lakh and above in every financial year, which liable the employer to deduct income tax from the salary. So as per the documents filed by the establishment, it was observed that it is more than 1 lakh. So the employer to deduct income tax from the salary and deposit it with income tax department, followed by submission of its prescribed return. For non-production of these valuable quarterly returns by the establishment, taking shelter of it being 6 to 7 year old cannot be accepted. So the authority says that had it been a case that the salaries were 1 lakh as claimed by you, there should have been TDS deductions and return filed by you. So the establishment has not produced these TDS deductions.
Further?
Yes.
This is because?
This is because as per IT Act rules, records relating to minimum 7 years is required to be preserved. Establishment says that it is 6 to 7 years old. I will not. The explanation of the establishment evidences that the employer has failed to deduct income tax from the salary and has not complied with income tax department or has prepared fake salary register to evade grant of membership under PF scheme. So these are non-production of the income tax return. So the authority doubted the wage register in which the wage was shown more than 1 lakh rupees to the employees. So the authority gives a finding that since you have not produced the income
At
tax
what rate have you calculated? What is the rate at which you have calculated?
No, that is at page 40.
Yes, what is the rate? Did you calculate any amount less than 6,500 per month? Wages?
Yes.
Yes. How many employees were involved? For how many persons have you assessed? Where is your inspection report? Where is the inspection report? Where is the inspection report?
No, that is not. That has not been filed.
Annexure 2?
Annexure 2 is the letter, my lord, it is by the enforcement officer. When he says that there is an inconsistency, so action should be taken. The list is not filed over here. The list is there in the letter, but that particular list, the enclosures are not filed, which contains the list of excluded employees. Because the calculation has been rounded off at the total wages drawn by them.
Yes, respondent.
In
such case, from the perusal of the order passed by the enforcement officer, not this assistant provident fund officer, it seems that the returns were not filed, and that was the reason as to why the adverse order was passed against you.
May I answer?
The appellate authority says that the returns were filed.
May I just answer this? My first point is that kindly see what is the date of the order which is under challenge. 23rd March 2011
Yes.
at page 42.
Yes.
And the writ petition is filed in the year 2016.
Yes.
5 years is the delay and no explanation in the entire.
Need not be, because these are actually related to the dues of the employees, and they are the custodian of their money. So these are the compliances.
So this is my first submission.
That's right. We'll
that-
take care of
that
it.
the writ petition
5
should
years
be-
delay.
Should be
We'll take care of it.
dismissed on this ground alone.
All right. We'll
And
take
for
care
this
of
purpose, I rely on a judgment.
Yes.
2014 4 SCC,
2014 4 SCC
page 108,
108,
paragraph number 16.
para 16.
This is one. Second point is that rightly it was pointed out by this honorable court that they themselves have come to the conclusion. It is observed that the salary of the excluded employee were always rupees 1 lakh and above. It is not that it is my submission. It is the finding of the Assistant Provident Fund Commissioner that the salary is always 1 lakh and above. So 12/60 एक साल में अगर 60,000 प्लस है, then these are the excluded employees. So you do not have any power and jurisdiction to enter into this. And thirdly, I'm just answering this. Thirdly, then on what basis you say that register was not produced or something was not? Then on what basis you took this decision?
You produce certain registers which they have disbelieved on the ground that there is no income tax returns
Then
filed.
the question would arise.
And but the appellate tribunal says that returns were filed.
Then the question would arise that on what basis this decision was taken. In guess, you guessed this that yes, the amount
No,
must
we
be more than
will
6,500.
remand the matter to the enforcement.
500.
Fresh adjudication करो and verify the records. Returns अगर आपने नहीं फाइल किया है तो आप फाइल कर दीजिए.
And was
Returns
this-
तो कोई ऐसा चीज नहीं है ना जो अचानक कहीं गुम हो जाएगा. It is a statutory document.
And the-
मर्जी हो तो इनकम टैक्स ऑफिसर को समन कर लीजिए.
And the tribunal says that the definition makes it clear that persons who had withdrawn all their benefits and persons who pay dearness allowance exceed rupees. In this case, the salary register number 1, the income tax return number 2, and the balance sheet reveals that these persons were receiving wages more than
The
6,500.
impugned order reflects that the returns were not filed. Therefore, it has to be considered. If the returns are there on record, it will be an open and shut case.
My lord,
As simple as that.
that is what I am saying.
Yes.
That it is an open and shut case.
No,
that
no.
the tribunal came to
The
the conclusion.
order-
The tribunal has said, my lord, in this case, the salary register 1, income tax return 2, and balance sheet reveals. So these things were perused by the tribunal.
So income tax returns were filed
This
according
is
to
what
you.
the tribunal says, and they have not said that this is a wrong finding. Let us see the whole writ petition, whether they have said ever that this is a wrong finding returned by the.
Monday को register पूरा record
by
produce
the-
कर दीजिए.
by
We will
the-
see whether the returns are there or not.
Yes.
You produce a record.
Yes.
This is before the tribunal.
No, not before the tribunal. आप 7A का proceedings का record.
7A का ला देंगे पूरा
record
वही ले आइए.
पूरा ला
कहाँ
देंगे।
का ये matter case?
मतलब
Right.
TDS
If it is
certificate-
not there.
TDS certificate, he has given a finding that TDS certificates were not filed.
So TDS not filing TDS certificate is irrelevant. That is a matter between the employer and the department and the employee, right?
Salary register reveals so, income tax return reveals so, balance sheet is revealing so.
Income
what
tax
more?
return file हुआ है कि नहीं हुआ है? This is what we need to see, right? TDS certificate file हुआ है कि नहीं हुआ है? It may not be relevant, but this order says that income tax return was filed.
The 7A says quarterly returns,
Hmm.
non regarding the TDS deductions. In any case, I will produce the entire record.
You produce it. Non-production of these valuable quarterly returns by the establishment. Quarterly returns regarding TDS.
Deduction of TDS. They are required under the statute to deduct it and pay to the income tax department.
The income tax returns were filed.
Yes, income tax appears to Yes, income tax was filed.
From where do you say this? From where do you say this? That income tax return was filed?
Along with IT returns, that is, the order, mid of the order proceeding, 1/0326/04 and 1/052067, balance sheet for 0304 and 0405 along with IT returns.
The IT returns are not sufficient. Yes, Mr. Counsel.
Well, the
Unless
IT,
for some unknown reason, these authorities want something more from me. What's
that is not.
after going
Tell
through
us.
the income tax and everything, you came to the conclusion कि 1 lakh से salary above है. Still you say that no, you pay this,
on
and the
basis
tribunal
of the
examined
main
every
rate of
aspect and then returned a finding
But
कि
they-
तीनों चीज देख के हम कह रहे हैं कि 6,500 से ज्यादा है.
7A का records मंगा लें.
जी हम ला
ले. Counsel for the parties are present. Counsel for the petitioner has challenged the appellate order passed by the tribunal to submit that the registers produced by the respondent were disbelieved by the Assistant Provident Fund Commissioner by passing the order under Section 7A of the Act of the Employees Provident Fund and Miscellaneous Provisions Act of 1952. But the appellate tribunal has observed that in this that salary register, income tax return and balance sheets revealed that the wages of the person concerned was within the excluded category of employees. It is further revealed from the records that the order passed under 7A was pursuant to an order of remand dated 6/1/2009 passed in WPC number 1914 of 2009 dated 6/1/2009, wherein primarily the objection was taken by the respondent before this court that the order under section 7A was passed without giving an opportunity to raise objection with regard to the inspection report.
yes, a report of the enforcement officer.
With regard to the report of the enforcement officer. The report of the enforcement officer is not on record. इनका objection है record पर? नहीं. Neither the report of the enforcement officer is on record nor the objection to the report is on record. The learned counsel for the petitioner is directed to produce the records in connection with the proceedings under section 7A. हमारे पास एक photocopy देंगे, original अपने पास रखें. A photocopy of the records be filed in sealed cover before this court. By 3rd July, by 3rd of July, the counsel for the petitioner will retain the original of the record, post this case under the heading for final disposal on 10th of July.
Just a copy to me also. It's a record.
ऐसा नहीं हो सकता. Record की copy ऐसे नहीं मिल सकती. You can आपको
कोई बात नहीं.
एक second. You can have an opportunity to peruse it. 10 जुलाई को सील कवर करने का जरूरत नहीं है. Just copy यहाँ पे produce करिएगा. और 3 जुलाई को आप copy produce कर देंगे. And if you make a request to this court, we'll permit you to peruse the records.
हम अपने कॉस्ट पर करा लेंगे. तो रिकॉर्ड का ये तो कोई छुपा हुआ चीज है नहीं.
नहीं ऐसा फोटोकॉपी हम लोग इस तरह से प्रोवाइड नहीं कर सकते. बेसिकली यही देखना है एनफोर्समेंट का इंस्पेक्शन रिपोर्ट क्या था, आपका ऑब्जेक्शन क्या था, राइट? That will clarify the entire position, and we'll see that where is the income tax returns.
If any copy is not given to me, I'll take the stand whatever is permissible in law. My lord is keeping in July.
It is the 10th of July for final disposal. It's all good.
Item 45, WPL 236 of 2018.
Petitioner.
Yes, there is a delay because the respondent has died. Respondent number
IE number?
is 5709.
IE number 5709 of 2024. Counsel for the petitioner submits that the respondent number 3 has expired during the pendency of this case.
Yes, my lord.
And accordingly, a petition for substitution has been filed. He has submitted that
Actually, they filed an IA informing this court based on that.
on the basis of disclosure made by the respondent
In IA number
in IA number
11507 of 2022.
11507 of 2022. The legal representative of the respondent number 3 has been brought on record, whose detail has been reproduced in the present IA in paragraph 4. Considering the submissions, the IA number 5709 of 2024 is hereby allowed. The counsel for the petitioner is directed to delete the name of the sole of the respondent number 3 from the cast title and insert the name of legal representative of the respondent number 3 in red ink during the course of the day. It is observed that the present interlocutory application, the present substitution has been allowed only for the purposes of the present case and will have no bearing on any other proceedings. Notice जाएगा, issue notice to the newly respondent number 3 through speed post as well as ordinary process, for which requisites be filed by next Monday. Post this case on 22nd July awaiting service report. Office is directed to prepare appropriate track speed post delivery and prepare proper office note with regard to service of notice. You want a red pen?
Yes.
Did you have a red pen?
Item 46, WPL 1904 of 2018.
On last occasion, my lord, respondent number 2 Union of India was made party and was directed to file counter affidavit. I will file counter affidavit.
Who is the intervener in this case? Who are you?
I am for the respondent.
Represented to
Whom are you representing? You will be represented by the union. You don't have an individual. Is it a case of termination?
No, not at all.
So therefore, you don't have a locus. Union has a locus. Union will represent you. That is the procedure, I suppose. You cannot be made party in individual capacity.
What happened state, my lord?
So we will expedite it. For early hearing, there is no problem. But so far as intervention is concerned, you don't have a locus. Somebody is appearing for the union.
Yes, I am.
You are for the union.
Yes, yes.
आप नहीं ठीक से बहस करेंगे क्या? Mr. Iqbal, you do
इसमें-
one thing. You come and assist this court. We'll hear you. Don't worry about it. But so far as intervention is concerned, we cannot allow the intervention. We will hear you. No problem. Everything is based on materials on record. There is no problem about it. It will come because union is seeking time to file a counter. What counter do you want to file?
No, on last occasion it was directed to file on order.
Bring
There is
on
order.
record a
There is order.
notification and the list of workmen that the notification had your location.
Okay.
That order was passed on.
कौन-कौन सा आई है बताइए?
20/9/2023 का ऑर्डर देखा जाए।
हाँ ठीक है।
20/9/23 का ऑर्डर।
हाँ क्या है उसमें?
उसमें ऑर्डर था, रिकॉर्ड आया था। रिकॉर्ड में पाया गया कि लिस्ट ऑफ वर्कर नहीं है, वर्कमैन नहीं है। तो हमने इनको डायरेक्शन हुआ था कि आप काउंटर फाइल उनको पार्टी बनाया था यूनियन ऑफ इंडिया। उसके बाद हम जो रेस्पोंडेंट है यूनियन, हमने सर्टिफाइड कॉपी ऑब्टेन किया लिस्ट ऑफ वर्कमैन का, जो रेफरेंस के बाद आया था, मांगा गया था, उसका हमने लगा दिया सप्लीमेंट्री। दैट वाज ऑन द रिकॉर्ड।
Union of India has to file a counter affidavit.
Yes.
Let them file it.
इसीलिए डायरेक्शन था इनको, उसी लिस्ट ऑफ वर्कमैन के। पिटिशनर का क्लेम था कि वर्कमैन का लिस्टे नहीं है।
आपने सप्लीमेंट्री फाइल कर दिया?
यह कर दिया।
सर्टिफाइड कॉपी फाइल?
ये सर्टिफाइड कॉपी लगाते हैं, फोटो कॉपी लगाए, सर्टिफाइड कॉपी आपको दे देंगे देखने।
But you file your counter. Which are the IAs?
आईए फॉर अर्ली हियरिंग, एक आईए है 17B का और वैकेटिंग एड इंटरिम स्टे। तो इसको फाइनली डिस्पोजल में रख दिया जाएगा।
We should let them file their counter. If we need to respond to it, we'll respond. Because if it is directly posted for final disposal, then we will not have any.
Learned counsel for the parties are present. आपका आईए नंबर क्या है?
99 of 2021.
$99 of 21 तो इसमें दिख ही नहीं रहा है. Where is it?
It is not. They have also not been served the copy of it. It's not yet marked. Although in the records it does show, in the website it is showing.
कहाँ है 99 of 21?
It was filed on 11/1/2021.
भाई ये सब पुराना आप लोग खुद से फ्लैट क्यों नहीं करते? इतना सारा ये लगा हुआ है यहाँ पर. You do it yourself.
All IA file for earlier will be kindly be disposed of below.
It will, because the date will be fixed. It will be
Yes,
disposed of. There is no
so
problem.
already that maybe has been successful.
The learned counsel for the petitioner submits that
Yes,
IA
ma'am.
number,
Yes,
उनका
ma'am.
IA number कितना है?
99 of 2021.
99 of 2021 has been filed on behalf of the concerned workmen. How many workmen are there, Mr. Iqbal? I can't hear you.
My lord, 54 are there. Total 54 are there.
54 workmen.
But my lord, I want to add on, my lord. We have filed a fresh wakalatnama. Total for 50 we have filed fresh wakalatnama. 4
And he is representing 50 concerned workmen. The learned counsel submits that since the right of the concerned workmen are involved, therefore the interlocutory application has been filed. However, it is not in dispute that the matter was taken up by the union before the learned labor court.
CDIT.
Before the learned tribunal. The counsel for the respondent union is present before this court. Considering the fact that the matter was taken up by the concerned tribunal and by the concerned union before the learned tribunal, and the concerned labor union is represented before this court is not inclined to allow the interlocutory application filed on behalf of the individual workmen. However, the counsel appearing on behalf of the concerned workmen may assist this court at the time of the final disposal of this case. Sufficient? Along with the counsel appearing on behalf of the respondent union, based on the materials already available on record. IA number such and such is accordingly disposed of with the aforesaid observation. So far as the other interlocutory application seeking early hearing of this case is concerned, the same are also disposed of in view of the fact that a date will be fixed by this court in the present proceedings. At this, counsel for the Respondent Union of India prays for and is allowed time till 10th of July 2024 to file the required affidavit as per earlier order. To this, as per earlier order by way of last indulgence. Pose this case on 23rd July. दोनों आइए क्लोज कर दीजिए।
There is a stay, so that means
कुछ नहीं, आप लोग को तो कुछ टाइम लेने के अलावा कुछ काम ही नहीं है। बिना सुने हम स्टे ऑर्डर नहीं करते।
it has already been granted. We just continue.
It has been continued till today.
Earlier there was a stay that was continued. There was a stay in this case.
Interim order till next date of hearing.
The interim order granted earlier will continue till जो date है वो डाल दीजिए 23rd of July.
May I take a leave, madam?
Yes.
Item 47, WPL 2079 of 2018.
Yes, petitioner.
Last week they have filed a counter affidavit with justice.
We are not concerned with counter affidavit. Records are here. We will not look at counter affidavit. We will only decide on the basis of record.
Can you also grant me some time because I have not gone through the records. So
कब करिएगा?
कुछ time दे देते because I need to contact my clients also.
The records have been received from the concerned court. Counsel for the petitioner seeks adjournment. You can post it to go through the records.
The records and maybe I'll have to take out some of the exhibits.
Nothing, it's there. Photocopy आता है records का. यहाँ पे original आता नहीं है, यहाँ से आपको certified copy मिलेगा नहीं. Workman है ना, तो आपको तो urgency होना चाहिए हर केस में.
urgency तो था. लेकिन
urgency समय के साथ खत्म हो गया.
They filed after such a long time. हमने ये
बताइए कब
लॉटरी
लगे?
4 weeks के बाद जुलाई के एंड में कभी लगा.
Pose this case on, at the request of the counsel for the petitioner, pose this case on 31st of July 2024 under the heading for final disposal. The rejoinder to the counter affidavit, if any, be filed latest by 24th of July 2024.
Item 48 WPL 2703.
लेबर मैटर में काउंटर एफिडेविट तो हमको समझ ही नहीं आता. एक्सेप्टिंग 17B वगैरह का
जैसे इन लोगों ने लगाया कई एग्जिबिट्स लगाए, तो थोड़ा सा उसको देखना पड़ता है.
Basically, counter is based on materials already on record.
My lord, counter, when we are preparing counter, पढ़ाई हुई है.
Yes, tell. पढ़ने का अच्छा है. Yes.
The order under challenge arises out of a complaint case which was filed by the respondent workman. In this case also by last order the LCR was called.
Again.
Although if I am required to argue on merits, before that we have two grounds. Primarily one, that the proceeding under section 33 capital A of the Industrial Disputes Act was not maintainable. So that is the primary ground on which we have been contending all along, that there was no violation of 33 because the earlier dispute related to the rate at which overtime allowance was paid, whereas the punishment is reversion and reduction to the initial pay scale, reversion in post and reduction to the initial pay scale, which is not connected with the earlier dispute of rate of overtime. And even if it is a punishment, 33(2)(b) permits inflicting a punishment only when the punishment is dismissal and discharge, that the proviso to section 33(2)(b) will be attracted, which requires the management to make an application simultaneously under the proviso. So the proviso is attracted only when the punishment is dismissal and discharge, and in this case the error is that the learned tribunal has failed to appreciate this aspect and has straight away in 2 paragraphs in the first page of the award held that there is a violation of section 33, punishment has been imposed, the pay has been reduced. The consequence is not the linking factor. What is the material term is whether it is connected with the dispute or not. And on that there is a recent Supreme Court judgment also of the Honorable Chief Justice, which we have placed on place for
Where is
hearing,
that judgment?
Durye Raj Spintex, in which the entire
If it is
provision,
related, you need to take prior permission.
if it is
If
connected,
it is unrelated, then you have to simply follow the procedure, inform the court, and then that particular dispute is taken up as an industrial dispute itself, straight away.
even if we follow that, following is also 33 to be proviso,
Yes.
only dismissal
Only
and
in case
dismissal.
of dismissal. This
Not
is your
otherwise.
case.
That is
Yes,
our
what do you
case.
say, respondent?
My senior will argue.
What were you never prayed for it? Who is your senior?
Mr. Rahul Kumar.
Where is
Maybe
he?
kept after lunch.
Okay, after lunch, right?
Otherwise,
I'll dictate a judgment post lunch and then we will take up your matter. That should be sufficient.
I think if we can succeed, that there is another judgment. Blue Star says that this is the primary, unless the foundation is there, that there is a violation of section 33, you
You
can't
give that
entertain.
judgment also.
I
Beside
have
that judgment also. Bring a copy.
I'll bring.
Next.
Item 49 WPL 3029 of 2018.
Yes, petitioner.
Counsel appearing on behalf of the petitioner has gone to fill out the treatment. It will be after 3 weeks.
The learned counsel for the petitioner seeks adjournment on the ground of illness of advocate on record Mr. Niranjan Singh. He submits that the matter be posted on, बताइए date बताइए. You are for the workman. You are for the workman. तो आपको कितनी मतलब कोई हड़बड़ी नहीं है आपको. रिकॉर्ड आ गए. बताइए कब रख दें. Are the records required? आर के शरण सेम ऑर्डर है तो तुरंत ही सेट असाइड होने वाला है. किस लिए आप टाइम मांग रहे हैं? अलाउ नहीं कर दें आपका केस. ऐसे नहीं हम करेंगे. छोड़ दीजिए. आप टाइम मांग रहे हैं. बहुत अच्छी बात. August 27th.
Item 50, WPL 533 of 2019.
Petitioner. Where is the petitioner? Yes, there was an agreement.
This is for appointment on compassionate ground. The award is
Mr.
at
M.K. Like, he's not well perhaps. Okay, WPL number 533 of 2019. इसमें record आया. Also for the petitioner is present, nobody appears on behalf of the respondent. Pose this case on 31st of July 2024. In the meantime, let the records be called for from the concerned court. Communicate through fax. Tribunal है?
हाँ ट्राइब्यूनल का.
Concerned tribunal. Detail दे दीजिए.
Item 51, WPL 1462 of 2019.
Yes, petitioner.
So earlier it was dismissed for non-prosecution. To that CMP was filed. The case is restored. The matter relates to for unauthorized absence. Petitioner was dismissed from service. Notice was given to reply and from the 72 hours. Notice was made for imposing minor punishment, but punishment was imposed in the terms of dismissal. Major punishment was given for unauthorized absence.
From where do I see that? Where is the impugned order?
Page number 23.
Read it,
Section
please.
3.
Read it.
My reference was denied.
Read it, please.
The subject was industrial dispute over alleged illegal and unjustified dismissal of service officer in Vishwanath Rajwar, minor ruler, personal number, by the management of the Katras Chatuli Colliery and Katras area of Mrs. DCA. Sir, I am directed to refer the failure of conciliation report number dated 17/5/2018 from the LC Dhanbad received in this ministry on 28/5/18 on the above mentioned subject, and to say that prima facie this ministry does not consider this dispute fit for adjudication for the following reasons. The Koila Ispat Mazdoor Panchayat raised the issue on 9/3/2015 relating to dismissal of Sri Vishwanath Rajwar with effect from 6/11/96 by the management of Katras Chatuli Colliery under Katras area of Mrs. BCCA after passage of almost 19 years from the cause of action without explaining the tangible reason for such an inordinate delay. As such, the ID is highly belated. In this connection, the judgment of Supreme Court from the body there.
What is the illegality? It's a stale claim. It is a stale claim. There is no doubt on that.
Lordship, let me submit my. For unauthorized absence, I went to visit my ailing mother.
We are
The
not on
family
merits. We are not on merits. You were dismissed in 1996. What were you doing thereafter? What was your general secretary or the union doing thereafter?
My mercy appeal was lots of illegality, lots of point of illegality. 72 hours notice was given for explaining my.
No, we will not go on the merits of the case. The reference has been declined. So, you might be having a very good case, but the reference has been declined on delay and laches. What do you have to say?
छः साल यहाँ हो गया सी अपील में रिप्लाई नहीं किए
कुछ रिप्लाई का जरूरत ही नहीं है.
Honorable Apex Court को भी judgment notice for unauthorized absence dismissal is harsh, disproportionate to.
What is your age? What is the age of the petitioner?
Also for last few times.
Age of the concerned workman.
Also.
What is the age?
About 50 years. About 50.
From where do you say?
Aadhaar card. His Aadhaar card. Also, I'm not asking for respondent to give me employment, only for an opportunity to have my say before the tribunal.
WPL number 1462 of 2019. Heard the counsel for the petitioner. This writ petition. Nobody appeals. Are you there? Counsel for the state is respondent is present. This petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner that the concerned workman was dismissed from service on account of unauthorized absence and the penalty is a major penalty. He has also submitted that the absence was not willful. In such circumstances, the impugned order refusing to refer the dispute for adjudication by the tribunal calls for interference. Counsel for the respondents has opposed the prayer. The impugned order refusing to refer the dispute clearly reflects that the concerned workman was dismissed with effect from 6/11/1996. And the dispute was raised on 9/3/2015 without giving any explanation for the delay. Even in the writ petition, no explanation has been furnished by the petitioner with regard to delay in raising the dispute. The judgment passed by the Honorable Supreme Court in the case of UT Bank Limited versus KP Madhav Kutti, it has been held as follows. In view of the aforesaid facts and circumstances, this court finds no reason to interfere with the improved order, refusing to refer the dispute for adjudication. Accordingly, this petition is hereby dismissed.